This video will give you a brief overview of the Australian standard patent process, beginning with filing of the application up until grant of the application. A standard patent will provide you with 20 years of protection for your invention. Typically, people begin with filing what is called a provisional patent application. A provisional patent application establishes a priority date for your invention and is typically suitable if the invention is not in a commercial ready form or you feel that there may still be modifications or improvements you would like to implement after filing. The provisional application will give you 12 months of pending patent protection before the application will lapse. To maintain your priority date, you will need to file a complete patent application. The filing date of your complete application officially starts your 20-year term of protection. The complete application is typically a more comprehensive version of your provisional specification, including further technical detail or information about any modifications or improvements you have implemented to your invention since filing the provisional. Once the complete application is filed, no further information can be incorporated into your patent specification. At this point in time, I'll just make a point to say that a provisional application may not be necessary in all instances. You may be ready to file a complete application at first instance, but this is something you should discuss with your patent attorney. 18 months after your first filed application, which in this example is a provisional patent application, your application will be published and available for viewing by anyone on IP Australia's online AusPat database. Now begins a waiting period, which is typically between 1 to 3 years in duration, where your application will sit in a queue at IP Australia waiting to be examined. When it is time, the Patent Office will issue a direction for you to request examination on your application, and you will need to pay a fee. You do not have to wait for the formal direction to request examination to be issued by the Patent Office. You can request examination early or even request expedited examination if that is in line with your commercial objectives. Your attorney should be able to help you with this decision. IP Australia will then issue an examination report on your application. From the date of issuance of this first examination report, you will have 12 months to put your application in order for acceptance. So, what is examination? Examination is the process whereby IP Australia assesses your application to determine whether your invention is worthy of receiving patent protection. The two main criteria that the examiner will assess your application on are known as Novelty and Inventive step. To satisfy Novelty requires that your invention is new or has a new feature not previously seen anywhere in the world. The examiner will search patent literature and any other published material that existed before your priority date, which, if you remember from earlier, is the date you first filed an application. In contrast to Novelty, Inventive step is a more subjective test. To have Inventive step, your invention cannot be considered obvious to a person skilled in the technical field of your invention. Now, what does that mean? Take the hypothetical example of a coat having buttons to fasten the coat. You may then come along with a new coat having zippers to fasten the coat. But because the replacement of buttons with zippers would be considered obvious to a person skilled in that technical area, for example a coat maker, the examiner may raise an objection to you on the basis that your invention, your new coat with zipper, does not have any inventive step. Obviously, this is just a hypothetical example. Inventive step can take a while to get your head around, and the best person to speak to again would be your patent attorney, who would give you their feeling as to whether you may meet the criteria of Inventive step. Once an examination report is issued, you would work with your patent attorney to prepare a response to the examination report. There are two main goals here. The first is that your response circumvents any material found by the examiner, and the second is that your application still maintains a scope of protection that is of commercial value to you. Here your patent attorney plays a big role and will help you to prepare and submit a response to the examination report that is in line with your commercial objectives. The examiner would then consider this response and, if the application now meets the criteria, accept the application. If the application does not meet the criteria, that is novelty and inventive step, the examiner may issue a further report, at which point it is back to the drawing board with your patent attorney. In some cases, the application may go back and forth several times before the scope of the application is settled between both you and the examiner. Once your application has been accepted, the details of acceptance will be published in IP Australia's official Journal of Patents, and your application will be open to opposition by a third party for a period of 3 months. This is an opportunity for people, typically your competitors, to object to the grant of your patent. There are a range of grounds on which the third party can object to your application. These include the criteria that were considered during examination, such as novelty and inventive step. For example, a third party may submit a document that was not uncovered during examination and claim that your invention is not novel or does not involve an inventive step in light of that document. After this 3-month opposition period expires, your application will proceed to grant and your patent rights will be enforceable. At this stage, there is nothing more for you to do but pay the renewal fees to keep the patent alive. I hope this video was helpful, and if it was, can you please press like so we know we're on the right track. If you feel that you may need some further information, please don't hesitate to contact us at Davies Collison Cave, and we'll be happy to go over the patent process in more detail and give you some advice particular to your circumstances.